Madam Foreperson, has the jury reached a verdict?
Yes, sir.
Would you hand that verdict to the bailiff who will transmit it to the court? Would the defendant please rise? In the case of State of West Virginia versus Natalie Cochran, case number 23-F-343K, the jury verdict is as follows. We, the jury on the issues, joined unanimously find the following. The defendant is guilty of murder in the first degree. The verdict form is signed by foreperson of the jury. It is dated 1/29/2025. There are no marks on the portion of the verdict form pertaining to involuntary manslaughter. Does the state wish to examine the jury verdict form?
No, Your Honor, thank you.
Does the defense?
No, Your Honor, thank you.
You may be seated. Is there a request for the court to poll the jury?
Not from the state, Your Honor. No, Your Honor.
All right. The verdict is received by the court and directed to be recorded. I'll ask the state to prepare an appropriate order in the premises. The court accepts the jury verdict and finds this defendant guilty of murder in the first degree. The defense will be afforded time to file all appropriate motions, and as we discussed earlier, we must have further proceedings concerning the aspect of mercy. I would like to do that right away, and perhaps to commence this afternoon. I can afford the defense or the state 2 hours to prepare, and we can go directly into the mercy phase.
Your Honor, as we pointed out to the court, we cannot have our witnesses prepared in 2 hours. Specifically, we anticipate calling the children. They are not close by at all. They're in school.
Oh. Well, Matthew? No. What? I can't hear you.
I've been corrected on that particular point, but we have to get in touch with our other witnesses. It will take considerable time to do that. We have to make sure they can get here, and we respectfully request to continue these proceedings and have the mercy portion sometime tomorrow.
What saith the state, Mr. Truman?
Your Honor, the state's prepared to go forward. We understand the defense situation. If they could proffer a number of witnesses they're going to have, that might be helpful. And if they can't start out today, then we defer to the court's judgment. All right.
Members of the jury, let me explain to you the circumstances. You have found the defendant guilty of murder in the first degree. There is another aspect that you must consider, and that is whether or not to afford to her mercy. If she receives mercy, she will be eligible for parole in 15 years. If she does not receive mercy, she will spend the rest of her life in prison. And that is a decision that you must determine. We must have a mini trial, so to speak, further proceedings for you to hear additional evidence in that regard and make a determination. You will have to return another verdict in regard to that matter. So the upshot of the situation is you are not finished with your responsibilities. And it is perhaps unfair to start into this right away and to force the attorneys to proceed in this very critical and important part of the proceedings. So it is such that we're going to start up at 9 o'clock in the morning. And I hope you'll understand, and I hope that you will continue to be cooperative and patient and considerate and proceed as you have already. You have been here promptly, and you have provided service as jurors in the manner expected, in the manner certainly I request. So here's the deal. I must still warn you and admonish you not to read anything, hear anything, talk to anyone about this case. And by anyone, I'm talking about your family members or friends, because tomorrow is another day insofar as you all are concerned, and we will proceed further in regard to the mercy phase of this case. So you're not done, and we need for you to come back. And you may be sad about that, or maybe you're okay with that. I don't see anybody throwing tomatoes at me yet. So hopefully you'll understand. We need to finish this out. We have much time invested in it, and we simply need to bring it to a conclusion. And I will need you back in your jury room at 9 a.m. I'll try to have a treat for you as a bribe for you to come back. And please follow my instructions. Don't watch anything on TV or see anything online. Again, for the purpose of this additional phase, I want you to have an open mind and to hear the evidence so you can make this additional determination. I can't tell you anything as to what you must do in regard to mercy, but if you have any questions about the procedure, or if you want to curse me, now would be the time to do that. I don't see any curses, and I don't see anybody complaining too much. All right, I will need you back in your jury room tomorrow by 9. Anything further before I let the jury go for the day from the state?
Not for the state, Your Honor.
From the
No, Your
defense.
Honor, thank you.
All right, you may follow the bailiff to your jury room, and I'll see you in the morning at 9 a.m. All right, we will start up for the mercy portion of this case in the morning at 9 o'clock. The defense will go forward first, sort of an unusual arrangement. There is no burden of proof, and it's sort of the wild, wild west, more or less. The court will be very lenient in terms of evidence to be presented. The only thing that I'm bound by is rules 401 and 403 of the rules of evidence. 401, of course, relates to relevancy. 403 requires the court to engage in the balancing to make sure that the probative value of any evidence is not outweighed by its prejudicial nature. Other than those restraints, the court can consider prior bad acts, the court can consider character, the court consider habits, almost anything that would be relevant and not unduly prejudicial to the defendant. So you are guided by that instruction, and we will start up for the mini trial in the morning at 9 a.m. Are there any questions or suggestions from the state?
Nothing for the state, Your Honor, thank you.
Anything from the defense?
No, Your Honor.
All right, court is in recess.